I'm going to turn it over to our attorney to tell us what do we have.
Thank you, Mr. Chair. We're here this morning to discuss the county's procedure moving forward for rehearing on the Weyer Gulch Road validation petition. By way of brief background, the county commissioners of Shoshone County were petitioned to validate what was alleged to be Weyer Gulch Road in Shoshone County by the petitioners Ryder Gautreaux and Chuck Jones, represented by counsel Rob Rembert. The county ultimately made the decision after the validation hearing concluded not to validate the road. That decision was appealed to the district court and was assigned to Bonner County Judge Beres. Judge Beres held a quasi-trial. It wasn't an actual trial, but it was a solicitation of evidence from the parties, so it functioned similar to the way a trial would function. And that occurred over the course of a couple of months. During that time, there was extensive briefing provided by the respondents, or the petitioners rather, to the respondents in the court regarding their position on validation. Also, in the course of that appeal, the Idaho Transportation Department petitioned the court to intervene as amicus into the action and to be a party for purposes of hearing and briefing. The court granted that and allowed ITD to be a party through that action. As such, ITD also filed extensive research exhibits and briefing for the court. Ultimately, the court heard that evidence. There was testimony provided. There was witnesses called. And at the conclusion of those hearings, the court ultimately determined that there was just too much new evidence that was presented to the court, which was not presented to the Board of County Commissioners in the original hearing, and has ordered that this governing body, that being the new BOCC for Shoshone County, actually rehear the validation case by way of all of the new additional evidence. That said, because there's so much evidence involved and the extensiveness of the briefing in this case, I proactively tried to get ahead of the ball for the commissioners and coordinate what this procedure might look like with the parties who were a party of action on the appeal, that being Mr. Rembert on behalf of the petitioners and ITD as interveners. During the course of that conversation, I believe the parties who were a part of the appeal action are all in a position and willing to stipulate to the BOCC simply receiving into your evidence at this point all of the underlying record. So this would consist of all of the evidence that was presented to the BOCC at the original appeal hearing, or the original validation hearing, all of the evidence that was received at the appeal hearing by the district court, and a transcript of the oral argument for the appeal hearing. That transcript's been ordered, it's been paid for, and we have it in written format for ease of use and reviewing by the commissioners now. Additionally, I inquired of the parties what their anticipated time frame would look like for oral argument. It sounds as if perhaps the two parties who were a part of the appeal at least believe they can limit their oral argument at the time of the hearing such that we would be able to conduct the entire rehearing in roughly 1 day. Obviously, that depends on how many additional individuals show up to also speak at the rehearing, as they wouldn't have been parties to the appeal, so we don't have any idea what additional testimony may be solicited from the community at large. With all of that said, I would recommend to the BOCC a couple of things to move you forward and to get you guys in a position to actually hear the evidence necessary to make a new decision on this matter. The first would be the BOCC should have in its possession all of the evidence that was a part of the original appeal hearing, as that would have needed to have been compiled and submitted up to the district court for the appeal. So I would just ask that that evidence be retrieved for your access so you can review that between now and the rehearing. The second piece is I would ask that the BOCC secretary get with my office and coordinate obtaining copies of all of the evidence that was submitted at the appeal hearing, compile that, and have it presented to you all for review as well. Next, there is the transcript, which I've mentioned we already have obtained a copy of. That will be submitted to you. And additionally, by way of new written submissions, counsel for Mr. Gautreaux and Mr. Jones has also submitted to me an appraisal report that they believe is important for your consideration, so I can submit that to the BOCC prior to the hearing for your review, in addition to the other documents. Looking at a timeline, I think that it would be prudent, based upon the voluminous amount of documentation you all are going to have to read through, that we look at bumping this procedure out for a couple of months to give you sufficient time to get through it all. As such, I would recommend that we set a target public hearing date of March 15th. I've reached that date after consultation with my office, the clerks in the courts, to identify whether or not it's likely that we would have the courtroom available on that date. If something comes up and it changes, we obviously can address that, but as of now, my hope is that we can reserve the courtroom on the third floor for the district court on that date, have it blocked off, and know that we have the ability to conduct the hearing for the entirety of the day if necessary. Moving backwards from that date, I would recommend the BOCC consider setting some target deadlines. This will enable all parties, including yourselves, to be able to have some degree of certainty what sort of evidence may come into the record, and to provide you with sufficient opportunity to review that prior to the hearing to make more sense of the oral argument that might be provided by the parties. To that point, I would recommend we set that date roughly 3 weeks prior to the hearing. That would be a date of February 23rd. Because of the type and nature of this hearing and the amount of evidence that has already been gathered and may still be getting gathered between now and March, I think it would be prudent to set that deadline both for written submissions to be received and as a declaration date for any individual desiring to provide oral argument or testimony to the BOCC to essentially sign up or declare, to enable the BOCC to coordinate times and arrange an agenda that can account for everyone's opportunity to be heard. On the back end, assuming that the BOCC would have had an opportunity to review all of the written submissions prior to the hearing, I think we can give ourselves just a few weeks on the back end to go back, review any of the oral testimony or argument that you might want to review again, to consider the arguments of the parties and to compare it against the evidence that you've received in your submissions, and actually form some opinions on whether or not you believe validation is or is not appropriate in this instance. To that point, I would recommend we set a decision date on the validation for April 5th. So using that same algorithm, bumping it back 3 weeks after the hearing for our decision. With all of that said, is there any questions for me about that procedure, what I'm recommending to the board?
I don't have any.
questions. I'm just double checking the calendar here. April 5th, you said?
April 5th would be a decision date.
Okay. Any questions from the board on that?
No.
So that's something we would need to act on today, right, to set those dates?
You can. Yeah, it certainly doesn't hurt.
Okay. And we did allow for action today. So. Okay. Well, how does the commission feel? At this time, I'd be interested, entertaining a motion to accept the dates as presented by council.
Yeah, this worked for me. I'll move to approve.
March 15th for the hearing date, February 23rd for deadline for written submissions and to register for oral argument, and April 5th for a decision of the board.
Correct.
I'll second
Any discussion?
No.
Okay, all in favor?
it. Aye.
Aye.
So now we've set ourselves a deadline for our homework. Okay. And it looks like mountains
Mountains of
of
homework.
homework. That's what it looks like. Okay. Anything else, Mr. Prosecutor, that you can think of at this time?
Nothing else from my office. Thank you, Mr. Chair.
Okay. Anything else from the board?
No.
Want to thank you for your time today.
Yeah.
It's going to be a learning process. All right. Well, with that, we are going to adjourn. Thank you.